Good morning, everybody, and thank you so much for joining. I see we can all see each other here. I think I'm gonna ask Pat and David to minimize their screens while we get the show on the road. So, as first things first, we want to say good morning and thank you all very much for joining us this morning, for your support and for attending. It is our first live stream event, so please be nice to us. Would of course like to thank Mr. Pat Pattinson for making all of this possible, and where our focus will be on the rights of creditors in a formal business rescue process. We would also like to thank our sponsor, BR360 Cape. Both of these people and this entity I will be giving a bit more of a formal introduction to in just a minute. I think I speak on behalf of all of the presenters today, where I would just like to express our excitement for the level of engagement that we've received so far on this matter. We were, of course, aware of the need to discuss a matter like this, but we are definitely blown away by the sort of engagement we've received thus far, simply just by the number of attendees so far, whether it be creditors in business rescue processes who are trying to educate themselves, or practitioners for whom they are also trying to educate themselves to ensure that they respect the topic of creditors' rights a little bit more. With regards to the bootcamp, I think everybody knows what a physical bootcamp is, but sort of more towards what our bootcamp is. Again, mentioning that this is our first live stream and our first event like this, one of many. We obviously decided to complete a short book on this topic, which will also be discussed. The process for today it's going to be rather intense. We've got quite a bit to cover in a short period of time. We suspect it'll be about 45 minutes or so. We will also be covering what we believe to be some of the more fundamental rights that need to be looked at. We'll obviously be looking at this in a very high level way, and we are looking to do a in-person session where we will sort of account for more than about a half a day. We're slating that for early next year, which will obviously also just help us to be able to engage with our attendees in person and just a higher level of interaction with regards to that. Just from a procedural side as well, like we did mention, there's going to be a lot of information shared in the next 45 minutes. If you have any questions, please do remember just to pop them in the comments section. These we can obviously have a look at. We will obviously be looking at these at a later stage as well. We will not necessarily have time to answer any questions in this session. So any of the questions that are asked in the comment section today will obviously remain on the event comment section, and we'll address those after the fact, which is also a nice little thing that everybody will be able to go and look at those questions and answers at any stage in the future. With regards to the sort of access to the information that we are giving today on the rights of creditors, we have written a short ebook. The book is very much written from a creditor's perspective, informing them and educating them of what their rights are. We have limited it to 26 rights. These are the ones that are easy enough to actually find in the Companies Act and identifiable. There are obviously more. These books are not going to be freely distributed to everyone. This book is not available for online download. We will be sending out an email after this meeting with a thank you for attending, and there will be a short survey. So in the email, there will be a short link, which is the link to take you to a survey. The survey shouldn't take more than 2 minutes to complete. Obviously, all responses are randomized and anonymous. There will, however, be a single input section for your email address. On completion of the the survey, you will then get a copy of our Rights of Creditors ebook, and we will then also add your email to our database so that we can notify you of any of the future boot camps and events that will be coming up. We will be doing a quick introduction. I'll also introduce myself, our big cheese as well, Mr. Pattinson, the main presenter for today. And then we'll also be just doing a short introduction of our sponsor for today, which is BR360 Cape, represented today by Mr. David Masterton. So just a little bit about myself. I'm a junior business rescue practitioner. I've been practicing as a practitioner for just over 2 years now. I have 4 years of experience in business rescue. I've been working alongside Mr. Pattinson since the beginning of my career anyway. Also work closely alongside with Mr. Masterton and various other practitioners. I did my LLB degree. I've done a handful of short courses in business rescue, insolvency, also business management. Currently busy with my master's degree in business rescue and insolvency at the University of Pretoria. I also did serve as the vice chair of the Dubai Small Business Chamber, and I currently serve as the Saripa Youngbloods committee member for the Eastern Cape. On to our, as I've mentioned, our big cheese, Mr. Pat Pattinson. He's a senior business rescue practitioner, and he has more than 17 years worth of experience in business turnarounds. So for those of us younger generation, that is before most of us even left high school, and definitely before the Companies Act was even integrated into our law. Mr. Pattinson has more than 50 substantial implementations of business rescue plans, with a success rate of more than 90% for all of those plans that were published. As mentioned as well, prior to the formal process of business rescue, Mr. Pattinson assisted more than 200 businesses with informal turnaround processes. Mr. Pattinson is also a published author, having written a book on exit strategies for small and medium enterprises. He has also written a business turnaround tips book, and as mentioned, the ebook that we are making available today, and also a number of other ebooks and articles. Furthermore, Mr. Pattinson holds non-executive positions on the board of multiple companies, and he is the CEO of the Turnaround Management Association of South Africa. So Mr. Pattinson obviously comes with a wealth of experience, and I think he's definitely one to listen to, especially with regards to a topic as important as the rights of creditors in a business rescue process. Next, we've got Business Rescue 360, who is our corporate sponsor for today. Business Rescue 360 is a corporate consulting firm specializing in the rehabilitation, restructuring, and rescue of financially distressed businesses. Whether these businesses are in fact in financial distress or just needing a little bit of help with creditor resolution process, you needn't look any further for a wealth of experience and knowledge. Representing BR360 today, we've got Mr. David Masterton, who is a CA and a licensed, experienced business rescue practitioner. He obviously also was involved with multiple informal turnarounds before the business rescue process became a formal process in South African law. Having mentioned, having worked with Mr. Masterton before as well, he's a very knowledgeable and experienced practitioner in his own right. So thank you very much as well for the sponsorship and for being here today to present with us. So the reason why we decided to focus on the rights of creditors, it is very much, as mentioned from the beginning, an educational driven approach that we have with regards to this topic, looking at it from a creditor's perspective. There's obviously a constant shift in the environment, constantly within the sphere of business rescue, even in the insolvency environment. And we believe that a better understanding of these rights and how they should be applied and how they should be addressed and respected at all times will result in, better results, not only for these creditors, but for the business rescue process as a whole. So we also are very much of the belief that business rescue and the culture around the respecting the rights of creditors is not supposed to be a bullying environment. We a lot of creditors not knowing their rights and not having their rights respected definitely do get bullied. And us obviously having been on both sides of the table, we've not just been business rescue practitioners with a bunch of creditors in our meetings. We have also represented creditors on creditors committees. So we understand the need for the respect of those creditors so that at all stages, everybody's rights are respected, and it's just a more harmonious process if everybody has a firm understanding of why the rights of creditors is so important. Just a very quick disclaimer. The information provided today is for general and informational purposes only. We are obviously not attorneys, and we do not, the material presented here today is not to be construed as legal advice. It's just based on our experience, our interpretation of the relevant acts, and obviously the years of experience. It's also just important to note that the views expressed here today are solely our own, and they do not necessarily represent the views or opinions of any of the professional associations or organizations that we are affiliated with. This project was obviously purely from myself, Mr. Pattinson, and Mr. Masterton's viewpoint, and we just obviously thought it necessary to bring in some experience and some discussion on the topic. Then moving swiftly along, I've already done the formal introduction of Mr. Masterton, but I would like to welcome him to the stage and to thank him again very much for sponsoring the event and also for attending the event to give us a bit of knowledge and a bit of insight from his point of view. Thanks very much, David. Take it away.
Thank you, Jaco. Thank you for the introduction, and welcome to everybody. BR360 is very proud to be associated with Pat and with Jaco. It's been a fantastic journey being with them and doing rescues on their behalf. With them and doing rescues as part of that team. So when Pat and Jaco said, "Let's do this," it was a great idea, because our experience has taught us that in many business rescues, a number of the creditors don't actually really understand what their rights are, and that can lead to so many problems. So Pat came up with ideas saying, "Guys, let's do this," and I think Jaco and I jumped ahead and said, "Let's do this. I think it's a great idea." What they've asked me to do today is to go through the concept of what can go wrong for creditors if they do not know their rights in full. Now, at BR360, we have acted as business rescue practitioners, and we've assisted creditors as advisors, and we sat on credit committees. And we've been able to sit and understand the viewpoints of affected parties from both sides. Now, remembering affected parties are not just creditors, it's got to do with all stakeholders in the business rescue processes. When creditors, when they do not really understand or fully understand their rights, they often get taken advantage of in terms of the business rescue process. And I'm not saying that every business rescue process is like that, and not every business rescue practitioner takes advantage of creditors, but we've seen multiple cases where when somebody has a place that they're trying to, a certain direction that they want to go to, and the practitioners can often push that narrative to get to the outcome that they're trying to achieve. And this happens and can happen on a rescue, and it can lead to onerous conditions put on creditors that go far beyond the scope of Chapter 6 of the Companies Act. And that's something that people must be very mindful and understand those rights and what they can do. Often creditors will get forced into a position where they will relinquish their rights or their dividends due to certain interpretations of the Companies Act. And that's practitioners giving their interpretation and to the benefit of other affected parties. And I think the key aspect here, which people need to understand, is remember that in terms of Section 7K of the Companies Act, all affected parties in a business rescue process is a client of the practitioner. And it's a very, very important aspect to note. It's not just the shareholder, the directors who appointed the potential business rescue practitioner, but all affected parties. That practitioner is accountable to all. And that's something that at BR360 we take very seriously, that's why we pride ourselves on the ability on our processes of transparency and communication. Jaco mentioned when he first spoke about that at BR360 we've sat on both sides of the table, and I wanted to give you a couple of examples of what we refer to there. We've been requested to advise clients as advisors and or sit as on the creditors committee representing them, and we've done it. We've been involved in that aspect before business rescue plans have been adopted, and when business rescue plans have already been adopted, and they have then asked us to come in and assist them. Now, obviously, the big problem comes in is once a plan's been adopted, that document is a legal document, and there's very little that we can do. In the one instance that we were asked to assist with, it was for a large business rescue, and the plan had already been adopted, but the creditor was fortunately given the scope to get involved in the sale of the business, sale of the equity, and they had that right because they were a secured creditor. But the scope that we were initially given was to review the business rescue process or review the business rescue plan. And when we went back to the creditor saying, unfortunately, we can't assist on the business rescue plan because it's already been adopted, but let us help you go forward in terms of get the transaction over the line. And we were very successful in that, and it resulted in many, many hours of negotiation with the business rescue practitioner. But by understanding the rules, the processes, and what can be done, what can't be done, we were able to successfully help the client get over the line and get substantial implementation on the rescue and get their company out of business rescue. We've served as a chairman on the creditors committee of a very large business rescue. And this one was, what I can say, it was problematic. And the reason why it was problematic is because the practitioner in that one tried to dictate the terms of reference of the creditors committee. He set unrealistic. First of all, he tried to determine who could belong on the committee and who couldn't. I mean, section 145.3 says, so section 145 talks about the participation of creditors and the right of creating a committee. A practitioner can't say who and who can't belong on the committee. It cannot say how they can engage. Section 145.3 says creditors are entitled to consult with the business rescue practitioners. The practitioner can't determine the rules of that consultation. The Act just says you are entitled to consult. So in this point of matter, the practitioner tried to put unrealistic criteria as how the committee must act and behave and how they could engage with him. And that was not going to help in the business rescue plan. We were then appointed as onto the committee, and then the creditors then asked us to chair that committee, and we were able to improve the engagement between the practitioner and the committee. Unfortunately, in that process, we had to go to the practitioner and state, guys, this is what is stated in the Act, and this is how we have to do things, and this is what is intention. This is case law that's been around for many years, and that engagement probably took a little bit longer than what we wanted to do. And when a practitioner tries to impose himself on creditors and on the business rescue process, that often can lead to business rescues taking a bit longer than what they should do, which ultimately impacts that of creditors. The Companies Act serves as a statutory act that must be considered in business rescue. In some cases, the provisions of the Companies Act has been amended and even replaced by case law. And it's important that one must not just read Chapter 6 and go with that. One needs to make sure that they're up to date with the relevant case law in terms of getting the correct interpretation. It's common for practitioners to publish business rescue plans and allude to creditors that have proposed a plan as the only alternative to liquidation. Now, this is basically factually flawed. So what the practitioners often do is they say, here's my business rescue plan. If you don't agree to my business rescue plan, I'm going to liquidate. It's almost as if it's a tacit threat. And that is factually flawed as per the Companies Act. Because more specifically, if you look at Section 153, it provides us a number of alternatives. And in those alternatives, it refers to us making amendments, creditors coming up with recommendations, proposing amendments. And creditors are entitled to engage. They're entitled to ask. They're entitled to get the answers. They're also entitled, if they're not happy with the plan, to ask for an alternative plan. And those are certain things that are very, very important and enshrined in that of the business rescue process. The practitioners can't just turn around and say, this is my plan. I'm not prepared to accept any alternatives. If you don't accept it, I'm going to liquidate. That is definitely not what is the intention and what is said in the Act. In fact, a practitioner may only liquidate a business if the practitioner no longer believes there is a reasonable prospect for success of the business rescue. Liquidation is not an automatic in the absence of a plan being adopted. And I think that's so important for us always to remember. The one aspect we always smile as business rescue practitioners is around business rescue practitioners' fees. Now, I know we all think that's a hot topic, and it is. But Section 128 of the Act dictates what a practitioner can charge and what he can't charge. But some practitioners, unfortunately, go beyond that. There is the legislation is very clear. It's not a debate, it is clear. And they only really present their fee arrangement when they produce the business rescue plan. The Act clearly states that there needs to be a separate meeting and it must be voted on by the creditors. And the creditors should understand their rights when making that vote and in complying with Section 128. When you get the vote, you need to understand what those fees are, what are the contingencies that come with that, because practitioners are entitled to charge, as per the Act, as per the regulation, an hourly charge based on the size of the practice. And that's, and then understanding what the contingencies are. A final statement, but no means less important, a practitioner is required to provide affected parties with all the information that they could possibly require to decide when voting for or against the proposed business rescue plan. Whilst the intellectual property of the business must be protected, the practitioner cannot base his business rescue plan on assumptions or summaries, such as providing a value for the assets from the balance sheet. Rather, the required asset material list. There, it's quite specific. You need the facts to vote. In short, once a plan is published, a creditor has the right to ask for any information that they may believe to be relevant for the decision making when considering how to vote. The fact is, when you make a vote, you need to vote on facts, not on assumptions. So I'm going to now say thank you for the time. I've probably gone over my limit, and I know Pat's got lots to talk about. So thank you for the time, and over to you, Pat. Thank you.
Thanks for that, David. I think from your presentation, it is sort of abundantly clear why it is important for creditors themselves to also understand their rights, so that they themselves can be informed as to what they need to know and what they need not to know and how not to be taken advantage of. But I will not take any more time, and I know that Mr. Pattinson does have quite a bit to say, so I would like to reintroduce Mr. Pattinson, and he will obviously go through the rights that we have decided to pinpoint for today. Thanks very much, Pat. Off you go.
Good morning, everyone. And again, just a thank you from me for attending this morning. As Jaco and David have both said, it is our first one. We're hoping it will add some value, and more importantly, it'll contribute to the industry as a whole. When we talk about the rights of creditors, it's very easy to look into the Companies Act and see the rights as contained in the Companies Act. However, we cannot look at business rescue and only consider the Companies Act. There are various other acts that must also be considered. The VAT Act, the Tax Act, the Insolvency Act, to name but a few. However, the book that we have written specifically looks at 26 of the main rights that are born from the Companies Act. But before we get to those rights, I would also like to discuss a second form of rights, which are your tacit or your inferred rights as a creditor. Quite simply, those are the rights that are so basic, that's so inherent, that there should be no need for them to be included into any form of act. It is as if a doctor's manual must include the fact that we have to breathe to fill our lungs. Some of those basic acts are the expectation to get paid for the product or service that we have delivered. It's the expectation to be treated fairly, to communicate honestly with our debtors and our creditors. Those are the inferred rights. Now, by way of example, the biggest inferred right that a company has, or that you as a creditor have, is for your creditor to voluntarily submit to business rescue. Now, based on the perception and the reputation that business rescue have got, that doesn't really sound like a right. But we must remember that business rescue was born as a corrective and not punitive process. It is creditor driven, and votes are specifically there so that it's not space for abuse. Business rescue is there to give a company the opportunity to rehabilitate itself and to contribute and to be able to pay the creditors. In a nutshell, the main question that we must ask is, what is better, immediate and traditional liquidation or business rescue? Now, I, for a fact, having been a business rescue practitioner, having assisted creditors, having assisted debtors in whichever way around they go, can assure you that business rescue is not always the right answer. It's not always even the best answer. But when done properly, chances of it providing a better outcome is far greater than simply going into liquidation. Now, business rescue, again, has got a very bad reputation, and that reputation is born from what happened when it originated. And the bad reputation is now further being pushed simply by the bad reputation that it's got. And the purpose of our book is to just help us along a little bit to understand that if we were to contribute as creditors, if you were to vote, ask the questions, force the issues, that business rescue will mean so much more than what we believe it to be. Now, before we go into the categories, I wasn't going to do this, but I think it's important to maybe give an example as the legal side of business rescue, how complicated it can be, and why it's important for creditors to seek assistance and not simply go on what the history and what the reputation of business rescue is. So from a legal perspective, let's just quickly see how technical it becomes. Section 128 of the Companies Act gives a definition of financial distress. Section 129(1) states that if a board becomes aware that the company is trading in financial distress, they may file for business rescue. Now, the word may often creates confusion, but if we were to read further to section 129(7), it provides an answer to that may. And that answer is simple, that other steps have to be taken. And these steps include that you have to file a formal response to all the affected persons, not just the creditors, but to all the affected persons, stating quite clearly that the company is in financial distress, but that you are not filing for business rescue. This is a COR document that you download from the CIPC, and it is a formal written notice provided to the affected persons. We then look at Section 8G of the Insolvency Act, and that letter is quite simply an act of insolvency that you will have very little defense for. On the other hand, should you not file for business rescue and you believe it's the right thing to continue trading, the directors of a company opens himself to personal liability in terms of Section 77 of the Companies Act. Now, Section 77 of the Companies Act provides liability from the director to the company. So the company could claim from the director, the funds come into the company, and then the company can utilize those funds to pay creditors. But more importantly, there's also Section 2182. Section 2182 provides that any person is personally liable to any person that has suffered a loss as a result of a contravention of the Act. So again, the inferred question is, how do you suffer a loss? Quite simple, and this is something that we have experienced many times. A company goes into business rescue 2-3 years after the first time it became financially distressed. The first time it became financially distressed, it could simply not pay rent. However, if we look at the definition, that is where the financial distress started. And should the company at that stage have gone for business rescue, that's where it would have ended. But there's a belief that my balance sheet is strong. I owe my creditors 50,000 Rand. The building I can sell for 5 million, so I'm sorted. But the sale of that building should then be in the business rescue plan because you are financially distressed. Financial distress is not the same as insolvent, and it is not the same as, not being able to pay it right now or later. Now, 3-4 years down the line, not paying your rent or paying a staff member has turned into 10-15 million rands worth of debt. Should a creditor be able to prove that the board was aware 3 years ago that the company is in financial distress, but chose to continue trading? Now, one of the things they do to continue trading is to increase the overdraft, get additional loans, but that is simply creating debt to pay debt. The financial distress remains. So in that instance, the creditors might have a claim for the entire increase of debt between the initial filing of financial distress and when it eventually files for business rescue. We then go to the Companies Act and we look at 4 main rights, and that's the right to be notified. There's then the right to take part in the process, the right to oppose certain parts of the process, and then ultimately the right to vote. Now, when we look at the right to be notified, that right is to be notified not just that the company has gone into business rescue, but also the right that if you're trading in financial distress, but you've decided not to go for business rescue, it gives you the right to take part in the process, join the creditors committee, negotiate, communicate, and advise the practitioner, but you do not have the right to instruct. You have the right to oppose. So first of all, you can again oppose the filing of business rescue itself. Alternatively, you could even oppose a liquidation application if you as a creditor believe that business rescue would be a better outcome than immediate and traditional liquidation. And then ultimately, there's a right to vote. Several forms of vote, but we'll discuss that a little bit later on. Ladies and gentlemen, we are going to go through this very quickly. We are not really going to have time for questions, but if you pop your questions into the post or the comment section of LinkedIn, we will address those questions at a later stage, either formally in the post, or we might contact you directly. And as Jaco said, there will also be a survey coming out a bit later, but please feel free to ask those questions. I'll have a look at them and see how I can answer them throughout the process. So today we look at the rights of creditors, but what if these rights are infringed on? What if some of these rights are taken away and you feel that you need to take action? The first thing that we need to say, and I think David alluded to this, is that business rescue is a balancing act. It's a juxtaposed process for the business rescue practitioner who has no real clients. If we then look at the Companies Act Section 7K, it places the onus on a business rescue practitioner to balance the rights of all of the affected persons. Those affected persons include the creditors, it includes debtors, it includes the staff, but believe it or not, it also includes the directors and the shareholders of the company. So the practitioner has got a balancing act to do, and he cannot simply look at just one or just at the other. We must then further consider from an ethical perspective, utilitarianism, which is a concept where the belief in the greater good is obviously chosen. And that then goes to our next point on the vote. The greater good is in theory supported by the greater vote. Unfortunately, we know that votes are sometimes weighed by one specific creditor having a substantial larger vote than any others. But that is a topic for a different bootcamp. We won't allude into that today. If you still believe that your vote and anything else have not worked, we recommend alternative dispute resolutions, which can be done by an external party. It can be done internally where you simply communicate. You could use the creditors committee to facilitate that process in order to get the right answers to your questions from the practitioner. We have often seen, and in most instances where complaints have been laid or where there has been disputes in business rescue, that there is a disconnect between the understanding of the purpose and the process of business rescue versus the facts and the legalities thereof. We have creditors that want to collect their assets. We have creditors that want to be paid before everybody else because they are important. And once the process is explained and the various laws are explained to them in a formal manner, we see that there's a lot more active participation in order to get the business out of business rescue. Failing all of this, the court remains an option. It's an expensive option. It is a time-consuming option. And in business rescue, we unfortunately do not always have the luxury of time. If we can look at something like Schrodinger's cat, which we are going to adopt slightly today, we have a business rescue plan that's published. The business rescue plan says that we are going to pay the creditors 50 cents in the rand within the next 6 months. However, that is depending on the post-commencement finance that we have secured. The post-commencement finance is somewhere in a bank account. There's no dispute about that. However, there's a particular creditor that believes he's entitled to receive a bigger dividend than everybody else. He goes to court and ties the matter up for 6 months, sometimes a year. The fact of the matter is that the post-commencement finance that was secured, that's lying in the bank, even a month after the fact, 3 months later, is no longer sufficient to implement the plan as it was initially proposed. The debt has increased, rent has increased. If nothing else, the business rescue practitioner's fees and the fees for litigation has increased, making that plan that was once a brilliant plan completely unachievable. So it is important to just keep that in mind. As I've previously said, the ebook we have written includes 26 rights. However, being a bootcamp, having limited time, we have decided to look at Friday the 13th, and we are going to try and cover 13 of the most important creditors' rights that we can present this morning. Again, ladies and gentlemen, these are not the only rights. They are not the most important rights. They are the ones that we believe most applicable. These are the ones that we come across most, and I think we can provide you, the listeners, with the most value in discussing these various rights. So the first right that we'd like to discuss is a company submitting to business rescue. There are two forms of rights here. The first right is for the company to submit to voluntary business rescue. Again, we consider that business rescue must be constructive. It must not be punitive. You and your debtor must have the kind of relationship where you can expect him to file for business rescue and where he can expect the support. If he continues trading, he is infringing on your right. He is increasing the debt. So it is better for your debtors to file for business rescue as soon as possible. Then in turn, of course, should your debtor not be in a position to pay you, should he continue trading and you believe he should go to business rescue, a creditor also has the right in terms of section 131 to place that company into business rescue. Again, that is not a very simple process. There are certain rules, there are laws. It is a court case, it is expensive. But in a nutshell, and again, I don't want to allude to this too much because we don't really have time. Either the company or the creditor wishing to place a company into rescue have to be in a position to prove two main things. The first being, and also the easiest of the two, is to prove financial distress. Now, in terms of the definition of financial distress, any company that finds themselves in a position where it becomes likely that they will not be able to pay their debt as and when it becomes due in the next ensuing 6 months. In other words, 6 months before you miss that first payment, you are financially distressed and should file for business rescue. In practice, we know that financial distress is a sneaky beast. You normally only find out that you are in financial distress when you start missing payments or when you start getting letters of demand. But at that point in time, it's clear that you are in financial distress. The more tricky option here is to prove a reasonable prospect. It's easier to prove than a probable prospect. You don't have to prove it by fact, but there has to be a reasonable prospect for a rescue, for a turnaround of a company, whether that being that the company can rehabilitate itself organically, in other words, trade itself out of the position with the payment plan, or where certain parts of the company needs to be sold, the company as a whole needs to be sold to save the business, or a substantial amount of assets of the company needs to be sold. It doesn't matter, but you have to be in a position to prove that there's a reasonable prospect of a rescue. There has also been several instances where you simply rely on the Carroll versus Carroll matter, and you state that selling the company and winding it down in business rescue is more economical and faster and shows more benefit than a liquidation. This is very true, but if that is the basis of the application, there's a lot of other aspects to look into as well. The concursus creditorium, the rights of creditors, the prejudice, all those type of things. But again, that is a workshop on its own, so we're not going to go too deep into that. The first right that we're mentioning is to either have your debtors go for business rescue or for you to put them into business rescue. The second right is the right to be informed. Now, we spoke about this a little bit beforehand as well. You have a right to be informed that the company is in financial distress and that it has decided to go for business rescue. You also have the right to be informed should that company decide not to go for business rescue while trading in financial distress circumstances. You have a right to be informed of all creditors meetings and to participate in those creditors meetings. You have a right to be notified of all the court proceedings should there be any. Now remember, ladies and gentlemen, not all business rescues are court sanctioned business rescues. The majority of business rescue, and in fact, I only work with business rescues where the company decides to put themselves into voluntary business rescue. It is just a simpler process, and there's a lot less aggression than in the other ones. You have a right to be notified when business rescue is terminated. Now, business rescue can either be terminated once a practitioner finds that the company is no longer financially distressed, and he then terminates business rescue, handed back to the directors and shareholders. The other point is where the director determines in terms of Section 141 that there is no longer a reasonable prospect and that immediate and traditional liquidation will be better for the creditors. He then notifies the court, he does a liquidation application, and he so notifies all of the affected persons. The other manner is, of course, the best, where a business rescue plan is published, it is adopted by the creditors, implemented by the practitioner, and the practitioner files for substantial implementation. The creditors, of course, also have the right to be notified of the publication of a business rescue plan, the adoption of that business rescue plan, and that business rescue plan is, of course, binding on all of the affected persons. As Jaco stated earlier, it's a legal document. It's a contract between the creditors, the affected persons, and the business. We look at judgments such as, I believe it's the Erevan construction matter, that makes it clear that business rescue plan is binding on all persons, whether they knew about the process, whether they didn't know about it, voted for it, or voted against it. They are, in fact, bound by the provisions of that business rescue plan. Once a plan has been adopted, in some instances, the ability to fully implement that plan is also removed from the process. Something has happened to make it impossible. We mentioned earlier on that there was a delay, the post-commencement finance is no longer sufficient, and the business rescue plan as it originally stood is now no longer practically possible, supervening impossibility, or those smart words. The practitioners, the directors, the shareholders, and even the creditors cannot simply go and change the provisions of the plan. A new plan must be published, and all of the affected persons again have the right to be notified of the amendments to the original business rescue plan, and they have a right to vote on that proposed business rescue plan. Substantial implementation, as previously mentioned, is quite simply when the process has been successful and the company is then handed back to the directors and the shareholders. Okay, the third right we have is the right to oppose. You can say no. However, again, if we look at utilitarianism, the better of all affected parties and the reasons behind it. It is not an easy process to oppose the application for a business rescue. It can only be done via the court, but that does not mean you do not have the right. You also have the right to oppose a liquidation application and stating that business rescue will be better than that of immediate and traditional liquidation, and thereby requesting the court to convert that liquidation application to one of business rescue. You also have the right to oppose the appointment of a business rescue practitioner. David alluded to a matter that we were involved with some time ago, where the business rescue practitioner was employed by the company 2 years ago to create and implement a turnaround plan. He worked with the company for several months. The turnaround plan did not work. He was then again appointed as a consultant assisting with the financial restructuring. Ultimately, that did not work. He was appointed as an interim managing director of the business. He did that for 2 months, then converted his work into a business rescue process, and he was appointed as the business rescue practitioner. In an instance like that, it is quite clear that the practitioner or that practitioner in that instance with the history of the company cannot be independent and that he should not be appointed. In matters such as that, or even lesser concerning matters, the creditors are allowed and are permitted to approach the court to request the removal of a business rescue practitioner. And then in terms of Section 153, once a business rescue plan has been voted on, and even once it has been adopted, within a reasonable time frame, the creditors may ask for that vote to be set aside on the grounds that it's unjust and unfair. One must just remember that it's going to be very difficult for the court to decide to unscramble once the omelette is made because of something that have gone wrong. It is advisable to look into the business rescue process, communicate and act swiftly. If a business rescue plan contains the sale of a business, of assets or parts thereof, and those assets have been sold and you only get to court after the fact because you believe it's unjust, it's going to be very difficult for that to be implemented. So if you are opposed to the business rescue plan, it is best that you act as quickly as possible. And as I said earlier, you have the right to even oppose a liquidation if you believe it in the best interest of all of the affected persons. Ladies and gentlemen, then we look at the right to vote on a practitioner's fee agreement. Again, David alluded to this a little bit earlier on. I'll go into a little bit more detail. If we look into the Companies Act, they provide the hourly rate of a practitioner in Regulation 128. And that section states very clearly that the fees may not exceed as provided in that particular section. It's only the minister that may amend the hourly rates of a practitioner in terms of Section 143(6). I know there has been some creative practitioners who have made the hourly rate part of a contingency. In my mind, I do not believe that that is legal. I do not believe it is ethical. It's not my place to make the determination. That is my personal belief and not necessarily shared by anybody else. But I believe your hourly rate must be your hourly rate. However, the Companies Act does allow for contingencies as per Section 143. These contingencies are normally success fees on the adoption of a business rescue plan, success fees on the sale of certain assets, the success fees on various other matters. What must be remembered here is that these fees must be approved by a vote from creditors. A specific meeting for the purpose to vote on the fees of a practitioner must be called. That's quite clear in Section 143. But just while we're on the topic of votes, there are two forms of votes taking place in a business rescue matter. I do think we talk about that a little bit later, but just for the record, when you vote on the fees of a practitioner, it's a simple majority with no differentiation between connected and non-connected parties, and all votes are directly proportional to the debt owed by the business to the company from those creditors present at the meeting whom have exercised their votes. So when a company produces a business rescue plan and the practitioner has placed his fees into that business rescue plan, you cannot simply accept that those fees are adopted and accepted simply because the business rescue plan was adopted. Fees must be seen separate, and there must be a separate meeting and a vote for those fees. Ladies and gentlemen, I think we are running a little bit out of time, so I'm going to try and speed roll through this. Please continue adding your questions, contact us. We can do the bootcamp again. However, as Jaco also alluded to, we will be doing a full rights of creditors session early next year, which will be half a day. Okay, so creditors have the right to consult the business rescue practitioner on the proposed business rescue plan. They do not have the right to instruct the practitioner. They do not have the right to request specific categories to be created for them. But it is not practical for practitioners to simply provide a business rescue plan without any communication to the key stakeholders in the various matters. It also does not give the practitioner the right to only communicate with a select few. And that is why creditors committee in certain instances are very, very important. The creditors committee that I'm alluding to is formed in terms of section 147. That creditors committee will to a great extent communicate with the practitioner. They will communicate back with the creditors and so forth and so forth. In smaller matters, creditors committee is cumbersome and sometimes become an inhibitor rather than an accelerant, but it is up to the creditors to vote on whether they want to form that committee or not. They may consult with the practitioner, not instruct him. They may consider certain reports that he has provided, but they may not insist on additional information. And as David alluded to previously, we were in a matter where the business rescue practitioner actually went so far to give the instruction that the creditors committee must vote on behalf of all of the creditors. Obviously, that creditors committee was stacked with people that he favored, but you cannot do that. The creditors committee cannot vote on behalf of the greater body of creditors unless they are in possession of valid power of attorneys or proxy forms. Seventh right, ladies and gentlemen, this is one again where the juxtaposed process of business rescue becomes very evident. The Companies Act provides substantial timelines. It provides that the company must notify the creditors within 5 days that they've gone into business rescue. The practitioner must be appointed within 2 days. First meeting of creditors and staff within 10 days. The publication of a business rescue plan within 25 days. And then the vote on the plan within no longer than 5 days, but within 10 days. I've gone through this very quickly. Of course, the publication of the plan within 25 days, there can be a vote to actually have the plan or the publication of the plan extended. The point I'm trying to make here is that all of these timelines exist in the Companies Act. However, when we then look at the Panama Properties matter court case, it actually made it clear that there is no longer such a thing as an automatic nullity. Although the Companies Act stated, the court stated that all you will have if the practitioner does not adhere to these timelines, that creditor will have the right to approach the court and start the expensive and lengthy process of having the business rescue set aside in its entirety. So those are rights, but they have been affected. One of the questions and one of the topics that I look quite forward to discussing into the future, although the timelines does not justify the termination of the business rescue proceedings, could it still be seen as a contravention of the Act? And could someone be held liable if those timelines are unnecessarily delayed? But again, topic for a different day, ladies and gentlemen. Section 150 of the Companies Act makes it very clear that the practitioner must provide the affected persons with sufficient information for them to apply their minds whether to vote on or against a proposed business rescue plan. However, one must still consider that unlike a liquidation, this company is still supposed to continue trading and that it must and it has a right to protect its intellectual property. So to ask who the suppliers are, ask them what your fees are, what you're buying for, what your markups are. In certain instances, that is asking too much, and the practitioner cannot provide that. However, Section 150.1 states that the business rescue plan must contain a material list of assets. I have seen many plans where this is simply answered by a quote from the annual financials of the business stating that the assets of the company is valued at X amount. This is not correct, as a lot of these assets could have been written off and have zero values in the financials, but still have a material value to the creditors should it be auctioned. Just keep that in mind, ladies and gentlemen. What also happens is a lot of practitioners rely on the fallacy of false dilemma. This is a fallacy where they provide a limited number of options. If you do not adopt the business rescue plan, we will liquidate. This is not true. A business rescue plan, in terms of Section 153, the creditors have the right to actually ask for amendments, to ask for a postponement, to ask for an entirely new plan. We then go back to where the creditors are being faced with a business rescue plan containing the fees of the practitioner, and the practitioner does not give the option to vote on those fees separate. That is a false dilemma. Those options do exist. Ladies and gentlemen, I have got 4 minutes left. I have got quite a few rights left. If you're going to not mind hanging on, I can carry on, or I can stop right here. Just a thumbs up or in the comments if you guys would like me to carry on. But in the meantime, the 10th right is fallacies of adoption of the plan. Sorry, to facilitate the adoption of the plan. You have a right to facilitate the adoption of the plan by, first of all, voting in favor of that plan in terms of Section 152. Should a vote be against the adoption of the business rescue plan, any affected person have the right to make a binding offer to any other creditor who has voted against the plan. Again, that's a very cumbersome process that we will discuss at a later stage. What I'm simply trying to do here is to tell you that there are other options. And it's not a simple thing where if the plan is voted out, it's voted out. If it's voted in, it's voted in. Similarly, any affected person may approach the court to have that vote set aside. Even the practitioner may do that, a debtor may do that, or the creditors may do that. Again, a very lengthy process, and I'm more than willing to discuss that with you at a later stage. As I've also alluded to, you have the right to oppose the adoption of a plan, and you can vote against the plan or, again, approach the court. But ladies and gentlemen, as I said earlier on, do not wait to approach the court. And if the process takes long for you and your attorney to get the documentation together, to get a court date, notify the practitioner of your intention to oppose it so that he does not merely continue implementing a business rescue plan that cannot be reverted to at a later stage. Then the 12th and a very important one is that once a business rescue plan has been adopted, those creditors have a right to be paid, to receive their dividends, and to expect the company to act in accordance to that adopted business rescue plan. It's a binding document, it's a legal contract. However, the Companies Act, to a great extent, as far as I can see, are silent on the what if not. If the practitioner does not adhere to it, payments are not made, the what if not is not there. The only thing we can find is that you have the right to approach the court to have the matter set aside. Then the 13th right, and the most important one, ladies and gentlemen, you have the right to seek expert advice. I have again come across many practitioners that flat out refuses to communicate with any other legal representations. They allude that the Companies Act is built with creditors. They will speak to the creditors and not their legal representations. This is not true. You have the right to seek any form of legal advice. You have the right to ask questions. You might not get the answers you want, but you have the right to ask those questions. You have the right to insist on answers. The answers might not be what you want. The answer might be that I cannot answer you as that infringes on the intellectual property of the business, but it does not mean you cannot answer those questions. And then lastly, of course, you have the right to be treated with respect. You have the right to have the information, and you are not the one that are at fault, but business rescue is corrective, so work with everybody else. Ladies and gentlemen, thank you very much for your time. I do see we have got some questions, and we will consider those very shortly. Jaco, back to you. Thank you.
Pat, thank you very much. I think it is evident. I think we covered those last few rights in land speed record times. I think obviously there is much to be said on this topic. I think there's a lot more that we can say on this topic, and very clearly a need not just to have another, session like this one, but definitely also to have that in-person session, where we can facilitate a little bit more engagement from everybody and from all the participants, and we can maybe even have a live Q&A session. As we mentioned, the questions that we have received in the comments, we will address after the session. We will go and comment responses to these questions. If anyone else has questions after the end of the session, you can either contact us directly, or you can also just continue to comment on the event's comment section, and we will happily answer your questions there as well. Just a final reminder as well, after this, we will be sending out just a thank you email for your attendance with the survey link, which you can just obviously complete to get a copy of our Rights of Creditors book. A final thank you again also just to BR360 and to Mr. Masterton for the sponsorship of this event. We look forward to many more of these events. I think this is a topic that we'll definitely focus on, but we will also have many other of these types of engaging topics for discussion. David, I'm going to pop you back onto the stage as well. If you just want to also say a thank you and a goodbye, we appreciate your participation today.
Thank you, Jaco. And to the team, Jaco and to Pat, thank you very much. I thought it was very informative. I'm sure the audience found it to be very informative. It is hopefully the start of a number of these that we'd like to be part of, because I think it's so important, not only for the creditors, but just for the general public to understand business rescue. Thanks very much yet again, and look forward to seeing you again in the future. Thank you. Thanks, Jaco.
Perfect. Thanks so much, David. And then also, Pat, if you just want to pop on and say a thank you as well from your side. I think all of us would like to say thank you very much for the very insightful session. I think even though we have officially run overtime, I think everyone was, everyone's still hanging around. Nobody is ready to run away just yet. Thank you. Obviously, very, very, very informative. And we definitely look forward to the in-person event and definitely more of these online sessions. I think we can participate, for example, just actually have sessions where we focus on just one or two of these aspects, because I think some of them are, very big and very important for understanding.
Yes, Jaco, thank you very much. I just want to thank you and David as well for the assistance that you've given us in getting this already. David, for your input and the willingness to sponsor this event. Then, of course, thank you to all those that have attended. And just a little bit of a side note, when Jaco and I decided to run with this event, our initial target was to have 20 registrations and about 15 people attend. We've obviously gone well beyond that, 110 registrations. I'm not sure how many people attended. I've been too nervous to check. But again, thank you very much for everybody that have attended. Thank you for the questions. We will definitely look into that. I know that one of the burning questions was the limitations to LinkedIn. We will definitely look into how we can expand on these. We like to do them on public platforms. I know it's possible for us to also do it via YouTube, and that's definitely something we will be looking into the future. But from me, thank you very much. It has been an awesome experience, and we will definitely be doing a couple more of them in the future.
Fantastic. Thanks so much,
Thanks,
Pat. And I think we will cut the live session within the next couple of seconds. So again, thank you guys all for your attendance. We really appreciate it, and we look forward to seeing you guys at the next one. Thanks so much. Enjoy the rest of your day.